Well, good afternoon and welcome, everybody. Thank you for tuning in this afternoon. Welcome to the Grace Bible Church Legally Speaking webinar. And before we proceed, may I just open with the word of prayer. Heavenly Father, we thank you this afternoon for this opportunity. Father, your word says it is you who gives us the will and the ability to do what we do. We thank you for this privilege to share some knowledge with your children, for the empowerment of your church. Grant us eloquence, O Lord, and bless our leaders for this vision and this platform. We thank you for all this in the mighty name of our Lord and Savior Jesus Christ. Amen.
Yeah.
Thank you and welcome, everybody. This is a Legally Speaking webinar, Grace Bible Church International. Before we start, I just want to appreciate and acknowledge our leaders, our presiding bishop, Bishop Musa Sono and Mama Gege Sono, for this vision, this platform, for giving us this opportunity to come and share some knowledge with the church, the children of God. You will recall, some of you that have been joining the webinars before, that this is as a result of a seminar that was held in August, the Women of Destiny seminar at Grace Bible Church, where there were presentations that were made. And out of those presentations, there were a lot of questions that were asked that we couldn't cover on the day, we couldn't respond to on the day. And because of that, Mama then gave birth to this vision that we hold these seminars every Sunday to share and to answer some of the questions that were not answered. So today we are going to be speaking about family law, an aspect that affects all of us, and specifically marriages, matrimonial regimes, and the legal implications thereof. I am joined in this webinar this afternoon by Mr. Moody Mabengani. Most of you would know him from his social media pages. He is a brother, both in the faith and in the profession, an expert in family law, and that is predominantly his area of practice. Mr. Mabengani, good afternoon and welcome.
Good afternoon, Ms. Mtimunye and the fellowship at large.
Thank you so much. So I will just address you during this webinar as Moody, as we always address each other at work. So Moody, when like I said, we had a Woman of Destiny a seminar in our church in August, and on that day we made a presentation about matrimonial regimes and marriage types and the legal implications thereof. So as I explained, there were just a number of questions that were asked specifically about the implications of marriage in community of property, the switching in terms of changing matrimonial regimes and customary marriages, which a lot of our people have had to deal with. We've had a lot of situations where people entered into a marriage without being aware that they are married because they think that they are not. And they 30 years, 40 years, 50 years down the line, they have to deal with that marriage that they didn't even think existed. So I'm going to hand it over to you just to speak about marriages. What is a marriage legally? How it is entered into? What types of marriages do we have? And what regimes are applicable in marriages in South Africa? Over to you, sir.
Thank you, Ms. Mtimunye. I can define a marriage as a relationship between two or more spouses which have legal consequences. So that is a marriage. If it is a relationship which does not have legal consequences, then we cannot define that as marriage. And then we have three types of marriages. Also, I'm sorry, we have four types at the moment because there's another one which has just been passed. We have a civil marriage, which is a marriage which can be entered into by a man and a woman to the exclusion of all others. In this marriage, parties should be above the ages of 18 years and it should be solemnized by a marriage officer at the Department of Home Affairs or by a marriage officer who has been designated as such as a pastor, who have been designated as a marriage officer by the Department of Home Affairs. That is a civil marriage. This is a marriage which has been in existence for some years, which previously it was solemnized in court. That is the civil marriage. And then the second marriage that we can discuss will be a civil union, which was passed in 2006. This marriage can be entered into between two spouses, regardless of the gender. It was passed because there were people of same sex who were not covered by this civil marriage. So that's why the Civil Union Act was passed in 2006. In this marriage, parties should also be above the ages of 18 years of age, and it is also solemnized at Home Affairs. At the moment, the pastors are not solemnizing this kind of marriage. Then the third marriage, which has just been passed, is the Muslim marriage, which has just been passed. And then this one is not solemnized at Home Affairs, but by the Imam at church or at the mosque by Muslims. And then the fourth one, which maybe we may put emphasis on, will be a customary marriage, which was passed in the year 1998, and then it commenced in November year 2000. In this kind of marriages, the requirements are that parties should be above 18 years of age, and then they should consent or agree to get married to each other in terms of customary law. Then the third requirement, which in practice maybe has been problematic as sometimes, is that the marriage should be negotiated and entered into or celebrated in terms of customary law. That is the third requirement.
So you are now talking about the customary marriage, the legal requirements for a customary marriage.
Indeed, Dudu.
Right. Okay.
Which in practice there are problems because in South Africa we have different tribes with different customs and traditions.
Yes.
So it becomes to cause problems because we are intermarrying between traditions. So the act only requires that the parties should consent to marry
right.
of this law. In other words, regardless of maybe a Zulu person marrying a Sotho person or a Venda person, it's like we're intermarrying. Then there are conflicts around maybe the requirements as such, but the law only requires that the parties should be 18 years or above to agree to marry in terms of customary law. So once parties agree that their family should meet to negotiate lobola, we can just deduct that there is a consent between the parties to marry, and then the marriage should be negotiated. So once they sit around the table and then they negotiate that so and so I intended to marry, or our son has sent us to your family to negotiate lobola and to agree on a marriage, then we can see that that is a negotiation of the marriage. Then with regard to entering into marriage, there is no formality in terms of the act which is required that maybe this and this should be done in order to conclude that the marriage was entered into. So there are several ways of entering into marriage these days. And then the court are emphasizing the issue of residing together as husband and wife after the agreement of lobola, regardless of whether there was any amount paid or whether the full amount was paid, regardless of whether the marriage was celebrated or not. So it's like we're faced with a situation where parties may find that they are married, whereas maybe they didn't comply with some of the aspects or rituals in terms of custom.
Sorry, Mudi, I would like you to just elaborate on that and maybe just go slowly in terms of the requirements. So the first requirement is that obviously the parties must be above the age of 18 years old. Above the age of 18. The second requirement is that there must be consent. And you've just said in terms of the proof that may be required in court in terms of consent is the fact that families agreed to meet. That on its own is seen as consent between the two people that were intending to enter into the marriage. The third requirement is then the negotiation thereof. You have not said, you've said they sit around the table and they negotiate the marriage. You haven't said anything about the exchange of money. Does it matter if they've only paid 100 rands, or they have to pay a certain amount of money, or they have to pay the bride price in full for the customary marriage to be valid? And I also, while you answer that question, that I also want you to touch on the issue of the celebration, because some people say, they paid the money, they paid half of it, and we didn't celebrate the marriage, and I was not handed over, even though we lived together afterwards, or we didn't even live together, but because I was not handed over. Can you just slowly and like chronologically go through those requirements and what an example of that requirement having met would be?
Okay, with the issue of lobola, the court has held that even if there was no lobola paid, but as long as there was an undertaking or an agreement that it will be paid in future, then they've complied with that requirement. In other words, the act itself is quite about lobola. It doesn't say anything about lobola. It doesn't say anything about payment or full payment of lobola. And then the case law, which has been held, was that if they are, and then there is a lobola will be paid in future, then that part of lobola falls away. And then you also discussed the issue of handover. The act itself does not say that they should be handed over. Just that
It's
it
silent.
is one. Yeah, it's silent. Just that it is one of the aspects that parties comply with, or some customs comply with, that maybe they should be handed over. But the courts
Right.
are saying that even if there was no handover or actual handover of the bride, the parties have entered into marriage. In other words, the issue of celebration also, we should understand that section which deals with requirements, it says that as long as the marriage is negotiated and entered into or celebrated, in other words, it's not saying entered into and celebrated, but or celebrated. So celebration
Okay.
of the marriage is not an essential requirement as it's been ruled by the court.
So the essential requirements is just the age of majority, consent, and the negotiation
And the negotiation and agreement.
agreement between the two parties. Which
And the
agreement
families,
is the
because
yes.
when the families meet, they have to agree on the amount of lobola to be paid, and then there's to be an undertaking or a payment of some portion or full payment of lobola.
Does staying together after that negotiation have any legal implications in terms of the validity of the customary marriage? The fact that we never lived together, they came, we agreed, we never lived together, we continued the relationship, we're planning to enter into a civil marriage at some point, but then along the way, things didn't work out and we just left it at that. And I don't want you at this stage to go to to the leaving it at that, but just to talk about living together. Is it part of the requirements or is it not for the validity of a customary marriage?
Okay, living together assists parties in proving their marriage in court, because there is a presumption that if parties are living together as husband and wife after lobola has been agreed to, then they are married. They're married. In other words, that is a presumption. So it assists
Right.
in proving the case. So in the case where parties have reached an agreement but they never stay together, then I can advise that people should approach court for clarity, because in some cases maybe it's better to get a court order just to declare the marriage null and void, so that parties can know their status. Because you go to court today, they are going to tell you that you are married regardless of whether you stay together or not, as long as the other
The three
requirements have been-
essential,
because
as long
there
as
are-
the three essential requirements were met.
because the issue with customary marriage is that it's a process. It's not like a once-off session like at Home Affairs or with other marriages where we just sit with the marriage officer for about 30 minutes and then it's done. So with the customary marriage, it's a process. Parties can send their families to meet, and then they pay a portion of amount, then they pay after years, then they do members, so all these traditions. So it's a process. So it doesn't mean that
Right.
if one of the process maybe didn't okay, then the marriage was not entered into.
Okay, so the marriage is then entered into, it's negotiated. So legally, the first 3 essential requirements have been met. Along the way, things don't work out and the parties go separate ways and they meet other people. They get into a civil union with, or no, I beg your pardon, a civil marriage with those people. And nothing has been done about that. Maybe one of them or both of them move on. What is the legal consequence? Is that marriage a civil marriage? Is it valid? And if it is not valid, what invalidates it? And how can parties make sure that that marriage is valid?
Is a problem because this is what many people are doing. So parties who are in a customary marriage are not allowed to enter into a civil marriage with third parties. They can only marry the same person that they're married to in terms of customary law. And then the civil or subsequent civil marriage with third parties is invalid. Although maybe it may require that it should be challenged in court, because if it's not challenged, maybe we can just let the sleeping dogs lie. But if it's challenged, then it's going to give the surviving spouse, usually the surviving spouse, problems, because it is going to be found that it is invalid. So people should dissolve their first marriage, and Section 9 says that it can only be dissolved by a decree of divorce. So it is not between the families meeting and agreeing on the issue of dissolving the marriage and maybe noting it down and signing. It has to be by court of law. So that's the only way that they can dissolve by divorce.
And is this Section 9 of the Recognition of Customary Marriages Act?
Marriage Act. That's all good.
And then it specifies, it's specific that a customary marriage must be dissolved by a decree of divorce, which then means for a customary marriage to be dissolved, people must file for a divorce. They must approach a court of law and file for a divorce.
And then there are other cases where you find that at the time of parties entering into a customary marriage, maybe there was a civil marriage is happening in practice. Then parties should be aware that, in other words, the customary marriage is not valid.
Right. So it's like I'm married, or I'm married in a civil marriage, and my husband leaves. I don't know where he is. 3 years down the line, he meets someone. He goes and he pays lobola without having dissolved my marriage with him, and they're married customarily, and they can stay together 10, 15 years. That we are saying that marriage is invalid.
It's invalid, that's correct.
So it is the same legal principle with a customary marriage, and whether it comes before or after, the one that comes after the other is invalid.
It's invalid.
Now, what matrimonial regimes, and I don't know if, I don't think we've introduced the regimes, but the regimes would be like the 3 regimes that we have, because sometimes people mistaken the marriage types with marriage regimes. So what we've been discussing up to now is the marriage types. We've got 4 types of marriages, and our forecast, and our forecast today will be on customary marriages and civil marriages, because this is what we deal with on a daily basis. Now the regimes is the legal system that applies into the marriage, regardless of whether it's a civil marriage or a customary marriage. And we've got 3 regimes, right? Marriages in community of property. That is regime number 1, which applies automatically into all marriages. The second regime is marriage out of community of property with accrual. And the third is a marriage out of community of property without accrual. Can you just briefly explain the difference between these marriages? What in community of property means, what out of community of property with accrual means, and what out of community of property without accrual means?
Okay. Dudu, what is more important to understand, especially as Christians who are listening, is that the marriage on its own has consequences. So I think that is something that parties are not aware of. So when they decide to send their families to negotiate lobola, they should understand that once an agreement has been reached, then there are consequences. Once the pastor has solemnized their marriage or home office has solemnized their marriage, there are consequences. So people should be aware that there are consequences. It's not a matter of lily, 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 and then we are excited and then we forget. There are consequences. And some of these consequences can either build or break the parties because some of them are dying. So people should be aware. So with regard to marriage regimes, the default is community or property. So
Right.
everybody who gets married in South Africa without a prenup is in community property, unless if they are getting married as Muslims, their marriage
Right.
are an exception. They are automatically out of community property.
Yeah.
So there's a belief that parties who are entering into customary marriage are automatically in community property, as if
Right.
the other two, civil union and civil marriage, are not in. In other words, all these other three are in community or property by default if there's no prenup. And
Right.
then, which means that all the liabilities that the parties have, this is before the marriage, and all
Yes.
assets that the parties have before marriage, together with all assets that they're going to accumulate during marriage and all liabilities that they're going to accumulate during marriage, regardless of how these assets and liabilities are incurred,
Right.
are joined into one estate. In other words, going forward, the parties have a joint estate between them. So Ms. Mtumunye is no longer able to purchase a house or by bond or a car by finance without the other party's signature. Even
Right.
the assets that a party had before marriage, they are no longer able to deal with those assets. Like a house, you cannot sell the house. Even on death, you cannot even pass that property by will to whoever you want to pass it because now it is a joint estate. In other words, it's no longer your property. It is co-owned by the other spouse. The liabilities
Okay.
that are incurred by one party can be claimed from the other party. So there's no
Okay.
argument that I'm not aware of this liability or this liability was incurred before the marriage. No, it becomes part of the marriage. And
Right.
then there are issues of even maintenance. Is that to comprehend, but it's happening that even maintenance to other parties is part of the liability of the joint estate. If there's no payment, then the other party is going to be forced maybe to pay for the other spouse's child or previous ex-spouse if the party was married and there was order of maintenance and the other party is not paying. So in other words, there are joint liabilities in the joint estate. And then
Right.
this joint estate, if one is to go under debt review, both parties have to go under debt reviews. Like they are one thing, legally, consequences are going to apply other way. And then the joint estate will have to be divided upon divorce or upon death. That's when now it's going to be divided. And division here will mean that all liabilities of the joint estate have to be paid, and whatever is left as balance have to be divided between the two parties. So that is community of property.
Before you move on, Moody, to the marriage out of communal property. So you are saying even if one of the parties had a child before the marriage, or sometimes these things happen during the existence of the marriage, they have a child outside of the marriage. The other party, if they're married in community of property, can be held liable for maintenance of that child.
Yeah, that's what is happening. Previously, people were only going after area maintenance at the other spouse, but these days they are going for the joint estate just to maintain the other child. So it's happening in
And,
practice.
and if A and B are married in community of property, and I think this is what you said, A and B are married in community of property, and A goes around and accumulates debts and is not able to service the debts, to pay the debts off as and when they become due, and for some reason he was able to acquire those debts even if he acquired those debts before the marriage or during the marriage, the other party is liable for those debts.
Indeed, that's correct, Dudu. They are liable, and there are spouses in marriage who it's like they just love liabilities, but they don't want to pay. The issue is that they're going to
Right.
affect the other part because the creditors, once they find out that you are in the property, they can even attach the assets of the other part. In other words, to pay the liability of the
Yes.
other spouse. So that is what is happening in practice.
And that is also applicable when a person is put under debt review. So if your spouse is put under debt review, whether you were part of acquiring that debt or not, you are both automatically under debt review.
Both of them have to be placed under debt review. They should make that application together because they cannot deal with one party. Because
Yes.
remember now they are dealing with it's like between these parties, there's no separate estate. It's a joint
Right.
estate. In other words, both of them have to make an application and be placed under debt review.
So in marriage in commercial property does not only just affect your assets and your liabilities, it also affects your capacity to contract, which
Yeah,
means you
capacity,
cannot then contract without the other party.
the other part. And then even to bequeath in terms of a will, you don't have full capacity to pass your assets by will.
So you cannot say, no, I'm going to sort this guy out, or I'm going to sort this lady out. I'm just going to write a will and leave everything that I have to my aunt or to my children. You
But children,
cannot do that legally.
you cannot do that because you have limited capacity to act.
Thank you, Modi. Can we then just move on to a marriage out of community of property? How do you make sure that your marriage is out of community of property in the event that after you understand all the legal consequences of a marriage in community of property, then you decide, I want my marriage to be out of community of property? How do you make sure? At what point do you make sure that your marriage is out of community of property?
Okay. Parties before the marriage can enter into a prenup. In law, we call it an antenuptial contract. It's a prenup that they have to enter into before the marriage for their intended marriage to be out of community of property. And then if the parties are already married in community property or in any other regime, if they're already married and then they intend to change the marriage regime, it has to be by
Right.
agreement. It has to be by agreement between the two parties. Then
Right.
it can be changed. Then they will have to approach the High Court for an application to approve their intended contract. That's when now we'll draft the contract, advertise on the Gazette, and then also inform the creditors of these two parties that these two intends to change their marriage regime. Usually in practice there's no objection from creditors because their rights are covered by current situation. In other words, once you change, it doesn't mean that the creditors are going to be affected. Whatever liabilities were there before marriage or during marriage, both parties are still going to be liable to the creditors. And then after the court has approved the contract, then we'll have to go and register this contract with the deeds office. Then that after that day of registration, then the party's marriage has changed maybe to out of communal property. And then in that application, we also have to deal with the assets, current assets of the parties. So in other
Right.
words, we have to dissolve that joint estate, say for pension funds, because pension funds we don't. It's not deemed a joint asset at this stage. Only on divorce where we deem it to be an asset in the joint estate. So now we'll have to deal with all the houses. It's either the houses can be awarded to both parties or to one of them. This car can be awarded to either party. They have to deal with the estates before we proceed. So it can be done, in other words, before marriage and during marriage, but during marriage should be by agreement, and then the court has to approve.
So for the court to approve is that the parties must lodge an application in the High Court. That application, can they just walk into court and say we've come to apply, or what are the steps? Is it a complicated application? I hear you talking about advertising. Can you just speak about that the requirements that must be met. We must advertise on the Gazette, on the local newspapers, and what are the intent, what is the purpose of those advertisements? One that I can think of is that it's basically a way of telling everybody, especially the creditors, that these two people that you have jointly granted a loan or a house or whatever form of liability are now intending to no longer be joint. They want to now proceed as individuals. Do you have an objection? And what happens if creditors lodge an objection? I've heard you saying in practice, usually creditors don't lodge an objection. But what happens if people had a joint bond and they're married in communal property and the other one is not known where they are and the other one cannot afford to then pay the bond and finally you trace the person and says, no, let's change, but I'm not going to be able to service the debt, but we can change from in communal property to out of communal property. In other words, the agreement requirement is met and then they are prepared to make an application, but then post that only one party is going to be able to service the bond and they may not be able to have. What happens under those circumstances in practice?
Okay, the last scenario, the mortgages will not have a problem if parties are not changing their marriage regime, because either way, their rights are still protected. They still have a
Right.
right to sue either of the spouses or both of them.
Right.
Then the parties can agree to change their marriage regime, and then the one maybe will still continue to service the bond. So they're not going to
Right.
object because the other
Okay.
person is unknown. Yeah. Even if they are in areas, I don't think the creditors will have a problem because they are protected. Whatever was owed to them during or before the marriage by either of the parties, they're still protected. They don't have a problem with that. It doesn't mean that once the parties have changed, maybe they're going to rearrange
I
their
see.
liabilities or yeah,
So
this
at any stage, the parties can bring an application to change their matrimonial regime.
indeed do. The only liability that they're not going to be bound by jointly is future liabilities. In other words, from the date of registration of their contract, that's when now their liabilities are going to remain separate. And then with regard to the first question, the parties, I doubt that the parties will be able to do this application on their own because there has to be a notarial contract. Notarial contract is it's like a marriage contract. This is what maybe we can term a prenup if, let's say, they were not married. So that
Right.
contract will have to be drafted. It has to deal with the current assets and then future assets or future regimes. And then there has to be a notice of motion together with the founding affidavit and supporting affidavit or confirmatory affidavit by the other spouse. And the matter has to be issued in High Court. And then after issuing in High Court, they have to first serve the deeds office. This office will have to look at the contract and see if it is registrable because the deeds office has stringent requirements in regards to their documents. You don't just draft documents. It's like they've got their requirements on how to draft documents. For instance, further, maybe the first page should commence on half. The upper part of the first page will be for
Yes, yes.
endorsement. In other words, they've got these requirements where I don't think parties are going to be able to understand. And then the issue of advertisement will have to be done. Government Gazette. In other provinces, they'll also require that it should be advertised also on one newspaper. The purpose, indeed, as you have stated, is to inform creditors that these parties intend to change their marriage. They have to know.
Yes.
And then we also have to send the notice to all creditors by way of registered post. And then after that, we'll go and appeal in court, present the case. And then once the order has been granted, we still have to go back to the deeds office and lodge the marriage contract to be registered. Only a notary public can
Yes.
lodge or can register a contract at the deeds office. So
Deeds
that's
office, yes.
why I think that maybe it won't be easy task or it won't be possible, let's say, for a party themselves or herself to register to change the marriage regime.
So what you're saying, Moody, is that both a prenup which is an antenuptial contract, which parties will enter into before the commencement of the marriage, for the marriage to be out of community property, and a post-nuptial contract has to be drafted by a notary public. And it has to be notarialized, but it has to be drafted and sealed by a notary public.
I can say so, Ms. Mutmunye. Then there is a case law somewhere around 1970s which found that even the oral agreement, in other words, oral prenup, is valid between the parties. But I can just
But
say
how do you
that
prove it?
how do you prove it? That's the problem. So
Yeah, how do you
so
prove
yeah,
it?
I can say that parties should consider approaching notary publics or an attorney who can assist them with a prenup, because it can also be done via power of attorney, where an attorney takes instructions, draft the contract, and then the notary public can only attest and register the contract.
Thank you. Moody, can we then just talk about the difference between a marriage out of community of property with accrual? What does that mean? And out of community of property without accrual? What is the difference between those two regimes?
Okay, the difference here is upon dissolution of marriage. In other words, during the parties' marriage, there's no difference. The parties are not liable for each other's liabilities if they're married out of community with or without accrual. Either party still have powers to enter into liabilities or transactions without the other party's signature. So during the marriage, there is no difference. The only difference will be when the marriage is dissolved. Because
Right.
if we look at without accrual simply means that if parties divorce, each party is going to retain their respective assets. They will only have to worry about assets that maybe they jointly purchased. That's the asset that they're going to be liable for. And then if there's a joint bond, then they'll be liable for a joint bond together. So that one is by choice, but not automatically by the marriage. It's something that parties had a choice of purchasing a property together or separately, but then they chose to do it together. They're going to be bound by that liability, and then they are both co-owners of that asset. This is if they're married without accrual.
Right.
Yeah. So in other words, parties are able to marry today with their houses, pension funds, and then if they say along the way they divorce, they're going to keep or retain their houses, their pension funds. There won't be difference in terms of liabilities and assets.
So marriage out of community property without accrual, it basically means as you are, you will always be, right? Whatever is yours, whether you had it before, during the marriage, at the dissolution of the marriage, be it a divorce or death, is yours, right?
It is yours.
Marriage with out of community property without accrual means that from the what you had before you entered into the marriage is yours, right?
Yeah.
But what you accrue, what accrues of your assets from the date of the marriage up until the dissolution of the marriage will then be shared, isn't it?
That is with accrual.
Yes,
Ms.
with
Muthundi.
accrual.
That is with accrual. But the problem with this, I think it is the way you're stating it is like you are simplifying it. But in
Right.
practice, we have to look at how this accrual is calculated, because it is not an asset which is shared, but it is growth in assets which is
Yes.
shared. Then
Yes.
the method that we use
Yes.
there is that the assets that parties had before marriage can be excluded. And then from the
Yes.
date of marriage, we'll calculate the commencement value of the parties' respective assets. In other words, we'll have to
Yes.
look at the husband's estate's value and see how much is it at the time of the marriage, and then the wife's value at the time of the marriage. If let's say it's 0, from the date of marriage, then they are going to acquire assets either jointly or separately. But if the marriage is dissolved, we have to calculate the growth of their respective assets. And then if let's say we were to find that the husband now has 1 million, which is when we calculate his assets minus liabilities, In other words, the assets of the husband minus his liabilities, let's say the value is 1 million, and then the wife's assets and liability minus liabilities is 0. This means that they will have to share the difference, and at the end of the day, they're going to
Yes.
share equally from this difference. But
It-
it is not an asset which is shared. If let's say I'm married and then I acquire a house during marriage, and then the value of that house maybe at the dissolution of marriage is 1 million. I don't have liabilities. My wife does not have assets. She said 0. This means that I owe her 500,000, but not that I owe her half of my house. In other words, it's either I can source 500,000 and pay her, or I can sell my house and then after that I give her half of that value. So we share the growth, but not an actual asset. And then in practice, it has some loopholes because people, once they anticipate that they're going to divorce, they transfer their assets from their names or they sell these assets to reduce the value of their estate, or they incur liabilities to increase their liabilities, lowering the value of their estate, so that when we do this calculation, find that maybe they are the ones who are able to claim from the other spouse. So that's with accrual.
So does it have to be shared, the growth, I mean, does it have to be shared equally, or how it is shared can also be regulated in the antenuptial contract? Because how you then get into a marriage out of community of property with or without accrual is that you must sign an antenuptial contract, right? To say marriage in community of property is specifically excluded, and this marriage will be out of community of property without accrual. So if it's with accrual, what you've just explained is that in the contract itself, you must then have a list of the assets at the date of the marriage belonging to each of the parties, because that is what will give you the commencement value, isn't it?
Yeah, that people will list their assets if they want to exclude them from forming part of accrual. In other words, in this case, they are excluding the actual asset, let's say the house, the
Yes.
full house.
Yes.
Then sometimes
Yes.
there are those who does not want to exclude the house or the actual house, they just want to exclude the value. In other words, that's when now they're
Yeah.
going to evaluate the assets and then less their liabilities to get the commencement value. But what we normally advise people is that they should consider excluding the property itself, because it becomes
Right.
complicated to exclude these values.
Can you then say, we've excluded this, excluded that, and whatever has accrued in the event that the marriage is dissolved in divorce, we will share the growth 70%, 70 to 30, 20 to 30. Is it cast in stone that it has to be 50-50?
I think that agreement may be found to be invalid, and then that is what we try to avoid when drafting contracts. Because remember, we are talking about the law itself. This is the Matrimonial Property Act
Yes,
88
of 1994.
1984. Yeah. In
Yes.
other words, this is what it states. So people cannot contract out of what the law says. So I think
Yes.
if that can be happen, it may be found to be invalid, and then now it's going to render the whole contract invalid. So it has a formula. The act itself has a formula. Chapter 1 has a formula on how to calculate this accrual.
So it is fair to then say a marriage out of community of property with accrual is like a deferred in community of property.
I can say so, even though I can say that maybe its consequences
Differ.
differ or can be dire compared to income property. Because remember, income property, if let's say the husband has a house, is not able to sell that house without the other parties' signatures or consent. But now, with out of community with accrual, he's able to do so. Whereas after selling that property, he still has right to raise a claim against the other party. I think it is not fair as many people think it is.
And I mean, of course, people do that because when parties are approaching a divorce, all sorts of strange things happen. But we all know that that is unlawful, right? So is there a recourse for parties that are married, even that are married in community of property with accrual, to make sure that even though one of the parties has done that, those properties can then be traced and found, and those dispositions be set aside
No,
to
this one
ensure that the other party is not prejudiced.
a recourse is found only if they are in communal property, because if they are in communal property, they are jointly or co-owners of an asset, so they cannot
Right.
deal without the other part. But once they are married out with accrual, they own
They can do.
respective assets. In other words, they can deal with their aspects as they wish. That's what I'm saying, that compared to communal property, it's like it has this loophole. I'm not sure if it's a loophole, but it has this loophole that a party can transfer all their assets. Then after 3 years, 2 years, they institute divorce, but they're still going to be able to claim against the other part. Whereas they had assets, but they transfer those assets.
So, Mudi, now that we are here, so I think there's an understanding now of the three regimes and how they're applicable. Can we then just talk about the dissolution of the marriage? People, especially Christians, don't like this topic of dissolution of marriage because they think that when you talk about the dissolution of marriage, you're only talking about divorce. But all marriages dissolve at the point of death, isn't it? So when people pass on, the marriage ends. So what are the implications of each regime at the point of death of one of the parties?
Okay.
Because a lot of people come, that is the point in life where a lot of people come face to face with the consequences of a regime they chose.
Okay. Ms. Mtunya, if you can start maybe with, let's say, with the out without accrual, because that one is like, it's another marriage where there are no consequences as such. Because once a spouse passes away and then parties were out of communal property, they passed on. And then if they had liabilities, nobody's liable to pay their liabilities. In other words, I can pass on with my liabilities, millions of liabilities. My wife is not going to be liable to settle my liabilities. And then if I have assets, it will depend on whether I have a will or not. If I have a will, I can indicate what should happen to my assets. I have full capacity or 100% capacity to pass my assets by will. And then if I don't have a will, then the surviving spouse is going to be the beneficiary. And if the estate is above 250,000, then it will be the surviving spouse together with all my children. That is
Right.
if it's out without accrual. Then if it's out with accrual, we are going to do the calculations. The husband assets minus liabilities, then we get the value. Then we'll go to the surviving spouse, who's the wife, assets minus liabilities, we get the value. Then we weigh the value and see which one is greater. The one which is greater has to share to the one which is lesser. So we're going to share the half difference of the accrual. So in other words, if I pass
Right.
on and then my estate is 1 million, and then my wife's estate, she's surviving me, but she is at zero, then half of my assets, or let's say 500,000, has to be paid to her before we deal with with the outstanding share of my estate.
Right.
Yeah, and then in other words, there, my wife is not going to be liable for my liabilities if I pass on. Just that the
Right.
problem is that it can reduce her share from my estate. And then
Right.
if you say now I was to pass on, and then she's the one now who has higher estate, she owes me this accrual. It may have
Right.
a benefit on my creditors because they are going to get something from my estate, even though I do not have much assets, because that difference that my wife owe me will have to be transferred into my estate. And then before my estate is dealt with, maybe to share towards beneficiaries, they have to pay the liabilities. In other words, it seems like now she's paying my liabilities indirectly because she
Yes.
owes me it. And then parties here, it depends now. If your estate is less than your spouse's estate, you may have full capacity to pass assets by will, because now I've got, let's say I've got a house worth 1 million, and then my wife has a house worth 2 million. This means that she owes me 500,000. In other words,
This
I'm
is with
able,
accrual. Yeah.
Aquan. In other words, now
Yes.
I'm able to pass my house to my children by way of a will, and then she can just top
Right.
up maybe with this 500,000 that she owes me. But now, if now she is on the opposite side, assets um, are 2 million, and then my assets are 1 million. She's not going to be able to pass her house now because she owes me. In other words, it's a matter of selling that house and then pay me 500,000. In other words, if your estate is less, you can make a will and then you have full capacity to pass your assets. But if your estate is higher than the other spouse, you are not going to be able to pass your assets because you owe the other part. It
Right.
will be like in communal property when you pass on, you are not able to pass your assets in terms of will. And then with communal property, the other problem is that you may end up being liable for your spouse's liabilities, even though they've passed on. Because remember, his liabilities are your liabilities. It's like it's a joint estate. In other words, whether the person passes on does not, it's not going to absolve you from your liabilities.
He
So
continues to
that's,
live through you.
yeah, that's the problem because now sometimes you're paying liabilities that you don't even know of. So you're going to be, yeah, in other words, you're not going to run away from those liabilities.
Moody, we are running out of time. There's just two important aspects that I'd like us to address before we run out of time, which were part of the questions that were asked. So we have situations, and I'm sure you've also heard of this situation where Ubaba, they got married and Ubaba left many years ago, right? He is not known where he is. He is known where he is. He's not interested in anything. He's living with, he has another family where he is, and he's not interested. He's not going to come back home. Uma continues to work, builds the house, and is worried about how do I make sure that 20 years or whenever down the line, Ubaba or the children that he has in that marriage don't come and claim what I've worked for and take what belongs to my children because Ubaba left. And when they try, they want to maybe get him to make sure that the marriage is then ended legally, he's either not found or he's not cooperative. Can you just briefly talk about ending a marriage or filing for a divorce if you need to with to a partner who you can't find or is not cooperative? How do you do that in law?
It is possible in law. We do that by way of substituted service. In terms of the
Right,
law, the divorce summons can only be served by the sheriff. But
right,
in cases where the sheriff cannot serve personally to the other party, we
right.
can make an application to High Court or to the court which is dealing with divorce, if it's the regional court, to order that maybe there should be service by way of email, SMS, Facebook, WhatsApp, or it can also be by way of advertising on the newspaper if there's
Yes,
no any maybe contact detail that we have for the other part. So it can be done. And then it is also very, very important to understand that issue of separation does not absolve the or does not dissolve the marriage itself.
yes,
Because what happened is that you find that once you pass on, you are still married, the other party is still your spouse. If there's no will, it becomes worse because you're not going to be able to even open a file at the master's office. They'll want the other spouse because when they put their ID numbers on the system, it is going to indicate that this person is still married. Then you'll need to find the other spouse in order to proceed with the estate. And then that other party is still entitled to half of this joint estate, which only the wife has managed to build, whereas the other party did not participate. And then what is the another problem in law is that on death, there's no forfeiture of patrimonial benefits of the marriage because this is something that maybe we can claim on divorce if maybe there are grounds for the court to order that the other party should not benefit from the assets that the other party managed to build. But on death, there's no that provision. In other words, parties should see that if the other party has left and then they're not contributing to the joint estate, and then the one who's living with the kids intends to safeguard the interests of the children, they should consider to divorce, and then they can divorce.
Mundi, that's a very important point that you've just said, that because when people divorce, when the other party had abandoned the other one, maybe for years, and you build a house alone and you do this, you can, when you divorce them, claim that they forfeit. And unfortunately, we don't have enough time to talk about the forfeiture of benefits now, but they can forfeit that part of the 50% that they're entitled to by law, which we can say that it's not an order that courts dishes out by the day. It's not a very easy order to obtain, but when certain requirements are met, the court can grant forfeiture. But what you are saying is that upon death, that remedy is not available.
It is not
Which
available.
means your children cannot then say, my apologies, your children cannot then say, but Ubaba left 60 years ago. We don't even know where he was. We don't even know the person that you say, Ubaba Asmazi, Uma did all this alone. Therefore, he doesn't have a right to come and claim. They won't even be able to report that estate. They will have to go and find him where he is. So it is very important to then lodge, like make sure you get divorced, and it's possible, even if you don't know where they are, to divorce him or her, because the court has made it possible to, even if you have the numbers, you can serve the summons in terms of the Electronic Communications Act. I think you can serve the summons by WhatsApp or even on Facebook. And I learned there's a case that the court decided, I think a year or two ago, where a service by messenger on Facebook was declared to be valid and effective.
Yeah, and then something that parties should understand is that the other party may come back. That's the problem with estate. Once they know that there's assets, there's money, there's pension fund, the other party can come back after years. And then when they come back, it is the children who are left to fight these battles, and they're not going to win. That's the problem. So
And
parties should make sure
sorry.
that if they've separated, it's better to dissolve the marriage. And then the other problem that we have is that people are not even making wills. At least if there's a will, it can safeguard maybe at least 50% of the joint estate. But if there's no will, sometimes the other spouse who left years ago can come and take almost everything, and then the kids are going to be left in the streets.
And just talking about kids, Moody, because I think this is also important as we prepare to just end this webinar. Just when you talk about kids, does the invalidity of the marriage, remember at the beginning or during this seminar we said, or during this webinar we said, a person can leave and go and enter into another marriage. That marriage is invalid if this one has not been dissolved. But if the person has children in that subsequent marriage, does that affect their right to inherit from his share of the marriage and community of property from this marriage that he left? Are
No,
children affected by the invalidity of the marriage of their parents?
if you can repeat that, Dudu.
So A is married to B customarily, or even in terms of civil marriage, and then abandons B. He doesn't divorce, right? He abandons B. He goes and he marries C in an invalid marriage, because we've already established that that marriage is invalid. But he has children with C, all right? And then he passes on, and then he leaves a will that whatever I own goes to my children. Can those children of B and C inherit the 50% that belongs to B in the A and B
Yes,
marriage?
yes, Dudu. The children are able to inherit whether even if they are extramarital children, in other words, children born out of marriage, they are able to inherit from their father. And then the issue now may even be in the case where find that the joint estate is made up only of wife A assets. In other words, the husband can say, if I die, all my assets should go to my children. In other words, it's
Thank you.
50% of the first wife's assets. You
Well,
can,
thank you, Moody. Thank you so much, Moody, and thank you everyone for joining in. We literally left with a few seconds, but we do want to say, as we come to the end of this webinar, that the discussions we had here were just mainly for information sharing it's not legal advice that you can go to court and say, they told me I must do this at the webinar. If you need legal advice, you must consult an attorney. You must consult a notary public if you need to enter into an anti-nuptial contract. We are doing this to empower the saints and to make sure that you've got the information that we need. And thank you so much. And may I please then just convey on behalf of the leadership of Grace Bible Church and our father, the presiding bishop, and Mama Gege, say thank you, Moody, for assisting us. And can I just close in prayer? Heavenly Father, we thank you for this opportunity. We trust, oh Lord, that you'll help us and help our children to be on the right side of the law, and as you direct us for the perfection and the establishment of the saints in your faith. We thank you, oh Lord, in the name of Jesus Christ. Amen. Thank you, and we see you next time and in the next Legally Speaking.